Hello, everyone, and welcome to Uncivil Law. And for today's story, I have something special for you. It's the story of a police officer who arrested the wrong person. And they arrested the wrong person, possibly because of race. And the story of how this all came to be is truly a thing to behold. It involves a good Samaritan. It involves a whole bunch of people. It involves the T1000 of Terminator fame, who's clinging onto cars. It's just all kinds of entertaining. So we're going to tell this story from Pennsylvania, and we're just going to enter the action as it proceeds with the Good Samaritan and the T1000. Let's get started with that. This incident began with an offer of a ride home. After leaving a sports bar in New Kensington, Pennsylvania, where he had spent 2 hours watching sports, eating food, and drinking 2 beers, Harvard was flagged down by a stranger, Anna Mazzetti, who was standing outside the convenience store. Mazzetti asked Harvard for a ride home. So our hero, Harvard, enters the picture. Harvard is enjoying the game, having a couple beers, is on his way home, and a stranger says, "Hey, can you give me a ride home?" And he says, "Sure, why not?" So he's being a very good Samaritan, driving Mazzetti home. Now, maybe there's a reason Mazzetti wants to be driven home, and we're about to explore that reason because we're about to learn about Mazzetti's boyfriend, who is an interesting character to say the least. So let's learn a little bit about Mazzetti's boyfriend, and maybe there is a reason she didn't want to go home by herself. Upon arrival, Mazzetti's boyfriend, Stephen Sutton, approached Harvard's vehicle and began yelling at Mazzetti, making threats and trying to get Mazzetti out of the vehicle. So the boyfriend over here is not super happy and is yelling, making threats out of the car, using racial slurs, all kinds of fun stuff. Yep. Believing Sutton to be a threat, Harvard called 911 to inform the police of the situation and asked what he should do, which seems like a very responsible thing. Hey, this abusive boyfriend is standing outside my car and yelling. Harvard, afraid for both his and Mazzetti's safety, proceeded to exit the driveway while Mazzetti was still in the vehicle with Harvard. So he's trying to be responsible and is like, I'm not going to drop this girl off at this guy who's yelling while I don't know what's going on. Sutton re-emerged from the house and jumped onto the hood of Harvard's moving vehicle, a Ford Explorer SUV. So this is where the T1000 enters the picture. So much like the T1000 in Terminator 2, running through the parking lot, chasing at the car, chasing at John, and leaping onto the car with his hook-like hand. Much like the T1000, Sutton over here is the T1000. He sees the car backing out of the parking lot, and he bolts from his home, running down T1000 style, reaches out for the car, and now is hooked onto the car, this Ford Explorer. So the T1000 has met the Good Samaritan. Fantastic. Let's learn a little bit more. Harvard slowed the vehicle multiple times to allow Sutton to remove himself from the hood. Rather than remove himself, Sutton began pounding the hood of the vehicle and continued to threaten to kill Harvard. Super exciting. Harvard, while still on the phone, informed the operator that Sutton was on the hood and was threatening to kill him and Mazzetti. So this poor Good Samaritan over here is having a very, very rough day. He's having a very rough day. He was at the game. He was having a really good night. He was watching the game, maybe with some friends, having a beer or two. As a person who likes to watch the football game, I understand. Like last night, I was watching Clemson beat the crap out of Wake Forest and enjoying it very, very much with the Clemson Alumni Club in Austin, which apparently has quite a few members. Hello, Clemson Alumni Club. It's nice to know that you are a thing that exists. I was surprised by how many of you there are. Awesome. I'm looking forward to more fun times. So much like me, he enjoys going to the sports bar and being with friends. And he's on his way home and he sees this woman. It's like, "Can you give me a ride?" And he's like, "Sure." And so he drops her off, and now his night has just gotten started. He's got the boyfriend clinging to the roof of his car, clinging to the hood of his car, T1000 style, as he's on the phone with 911. His night has got more and more interesting with every passing moment. Let's read on. With Sutton still on the hood, and while on the phone with 911, Harvard drove onto the highway, where he drove at or about the speed limit. Which, depending on what we mean by highway exactly, we're talking somewhere between 45 and 75 typically miles per hour. And this guy is just clinging on. Once on the highway, Sutton, the abusive boyfriend, ripped on the windshield wipers off the vehicle. So even though they're on the highway doing highway speeds, This guy is still trying to tear into the car. Man. Harvard remained on the phone with 911 and requested assistance from law enforcement. The 911 officer instructed Harvard to take a specific exit from the highway where law enforcement officers would be waiting. While exiting the highway, Harvard observed Sutton discard what he believed to be a firearm hidden in his waistband. So this guy's evening continues to progress with just wonderful glee. He is now on the highway, and the word exit does suggest interstate. So we're thinking like 60, 65, 70 miles an hour or something like that. Because we said we're driving at speed. And this guy is just clinging to the interstate, clinging to the hood, and still trying to climb into the car. Man, this guy is determined. And he says, the 911 says, why don't you take a specific exit and we'll arrest the bad guy. Unfortunately, who the police determined was the bad guy has led us to the incident. Are they going to arrest Sutton? No, of course they're not going to arrest Sutton. Who are they going to arrest? They're going to arrest Harvard. Even though Harvard is a Samaritan. So Harvard's night just gets worse and worse. He saw a handgun. He told the police about it. Do the police care about the gun? Of course they don't. Of course they don't care about the gun. Of course they don't care about the abusive boyfriend. Let's arrest the guy in the car. That's super. Let's read on. Following the 911 operator's instructions, Harvard exited the highway as directed and reached a police roadblock where the officers had their firearms drawn. At that point, Harvard had traveled approximately 10 miles. 10 miles, that's a lot, with Sutton on the hood of the car. Wow, this guy has a grip, man. The officers ordered Sutton to get on the ground and ordered Harvard and Mazzetti to exit the vehicle with their hands in the air. Sutton was handcuffed and placed in the back of the patrol car. Oh, thank God. It's all over. But of course it's not because, yeah. The defendant, state trooper Cesnalis. So Cesnalis, the state trooper, enters the picture. So who's Cesnalis? Harvard informed Cesnalis, the state trooper, of Sutton's violent and threatening behavior and told Cesnalis that he was afraid for his life. Cesnalis did not respond to the explanation and made no effort to locate either the knife or the firearm. What I missed from an earlier point of the opinion that I didn't highlight was when he ran out to the car, he had a butcher knife and apparently also a gun. So he had a butcher knife and was trying to knife at him. And Cesnalis over here, now Cesnalis is on the scene and now going to try to figure out what's going on. And it's like, he had a knife and a gun. It's like, I don't care. What do you mean you don't care? Instead, Cesnalis asked whether Harvard had been drinking. Harvard responded that he had consumed 2 beers approximately 4 hours earlier. After 6 tries, Harvard completed the breathalyzer test, which indicated his blood alcohol content was 0.064, which was below the legal limit of 0.08. So Cesnalis here is doing a breathalyzer on Harvard for some reason, and Harvard even passes. But even though he passed the breathalyzer, Cesnalis nonetheless inferred that Harvard was under the influence of stimulants or narcotics because he was sweaty, speaking rapidly, and not answering questions. Well, geez, why might he be sweaty and speaking rapidly? Maybe it's the massive amount of adrenaline that's in his body. Maybe that's a factor, but no, it must be drugs. Harvard was then handcuffed and taken to the police station for safety reasons. Wow. So the Good Samaritan over here is arrested and taken to the patrol car, even though he's not drunk, because he must be on drugs, because he's sweaty. Cesnalis, our hero, the state trooper, interviewed Sutton, the horror show guy. All right. At the time of the interview, the police officer, the state trooper, Cesnalis, was aware that Sutton had a criminal record and had prior encounters with the police. So Cesnalis over here is doing an interview with Sutton, and he's aware that this guy has a record, which of course he does, because you kind of knew that before we ever did this case, right? You knew he had a record. He's had a record of violence and runs in with the police, you don't say. So he knows all that. Sutton told Cesnalis that Harvard had hit him with a Ford Explorer and that Sutton had landed on the car. Cesnalis, our hero cop here, did not ask any follow-up questions to probe this explanation. Despite the incredible statements and Harvard's account of the incident, Sutton was not arrested or charged with any crimes. Despite the fact that we know that he has a criminal record, despite the fact that we have testimony from Harvard and presumably Mazzetti, who remembers in the car the whole time. Our friend, our hero over here, our hero police officer is not going to arrest Sutton. Nope. I don't see anything wrong with any of this. I don't see anything that I can charge this guy with. I know about the knife. I know about the gun. I don't see anything. I know about his history. I don't see anything I can charge him with. All seems fine. So who are we going to arrest? You know the answer to this question already. Let's press on. Cesnalis arrested Harvard, the Good Samaritan, and transported him to the police station for further investigation. Harvard again tried to explain that Sutton had a weapon and had been threatening Harvard and Mazzetti, but Cesnalis ignored these statements. Based on information Cesnalis provided, Beartree ran a series of tests to determine whether Harvard was under the influence of drugs or alcohol. His blood alcohol level at the time of that examination was 0.051. So now we have a second test that also shows him to be under the influence. Betty requested that Harvard consent to a blood test, and Harvard agreed. The blood test later returned negative results for all tested drugs, and indicated that his blood alcohol level was 0.016. The field test for the DUI showed him under limit. A second, presumably breathalyzer test, although it's not specified, but presumably a second breathalyzer test showed him to be under limit. And then a blood test showed him to be way under the limit, 0.016, which is low enough that it's not even DUI for commercial drivers. The DUI limit for commercial drivers is 0.02. So 0.016 is low enough that it doesn't even qualify as DUI for a commercial truck driver. That's how low it is. Are we going to admit to our mistakes? No, we're just going to double down. Cesnalis, because of all this wonderful evidence showing him to be a drug-addicted, alcohol-fueled guy, because exactly the opposite of those things, he charged Harvard, the Good Samaritan, with reckless endangerment, reckless driving, simple assault, aggravated assault, disorderly conduct, and driving under the influence of a controlled substance. I'd like to once again remind you, we have a blood test that shows that he was not under the influence of literally any tested substance. In his affidavit, Cesnalis, the patrol officer, referred to Sutton as the victim and entirely credited Sutton's version of events. So this is going super well. So once again, just to bring you up to speed, the T1000 here, clinging onto the car and ripping out the windshield wipers of the car, with knife in hand and gun in waistband, is not arrested or prosecuted for literally anything. However, meanwhile, our erstwhile hero, Harvard, having done his Good Samaritan hearing for the day, has had 3 different drug tests, all of which just shows that he's below the legal limit and not on the influence of any drugs. And he was trying to do the right thing and under the direction of 911. And for all this good stuff, we're going to charge him with 8 different crimes. Wow. Way to go, Cesnalis. You couldn't have screwed this up anymore if you tried. Wow. Super. Amazing. Deep. Great. Cesnalis indicated that he believed Sutton's version of events because Harvard had a reputation for criminal activity, despite the fact there was no evidence that Harvard had a criminal background. Cesnalis said he believed Sutton because of Harvard's extensive criminal record. Cesnalis is aware, at the time he said this, of Sutton's criminal record and the fact that Harvard doesn't have one. Yet he said exactly, literally the opposite of those things. He said, I believed Sutton because of Harvard's criminal record. No, wait, no. Harvard isn't the one with the criminal record. That would be Sutton. So why did you believe Sutton? Because he's a good old boy. Yes, he has a background even though he doesn't. Cesnalis omitted several exculpatory facts from the affidavit. For example, Cesnalis did not include the fact that Harvard initiated the 911 call because he feared for his safety, or that he followed the 911 operator's instructions, which guided him to the police barricade. This arrest warrant is going super, super well. I believed Sutton because Harvard is a criminal, but he doesn't have a record. And I also left out the fact of him making the 911 call and all that stuff. Harvard, the Good Samaritan, brings a 1983 claim against Cesnalis, alleging false arrest, false imprisonment, malicious prosecution, violation of equal protection, reckless investigation, and civil conspiracy to deprive him of rights. So Harvard here is not thrilled with him being arrested and charged. He was found not guilty, by the way, of all the criminal stuff because, they all fell apart. So after the criminal trial completely fell apart, he sued because of all this stuff. So let's learn a little bit more about the lawsuit. The district court grants summary judgment for the defendant on all claims. The district court saw no problem with any of this. The district court said, yeah, this is fine. For false arrest, false imprisonment, and malicious prosecution, the district court concluded no reasonable jury could find probable cause lacking. For equal protection, the district court ruled that Harvard failed to identify a similar situated person who was treated differently because of race. For the reckless investigation claim, the district court determined our circuit had never recognized such a claim under 1983, and even if they were to recognize it, the officers would be entitled to qualified immunity. So the district court saw no problem with any of this. No reasonable jury could find that the officer lacked probable cause. No reasonable jury could find that Cesnalis did a bad. What are you talking about, Harvard? We don't see any problem with any of this. So now the Court of Appeals has to address whether or not the officer did a bad. Did the officer do a bad? And if so, is there qualified immunity? Let's find out. To bring a claim for false arrest, a plaintiff must establish there is an arrest, and the arrest is made without probable cause. Summary judgment for false arrest and false imprisonment is proper only if no reasonable juror could find a lack of probable cause for any of the charged crimes. Probable cause exists if there is a fair probability the person committed the crime at issue. An officer has probable cause to arrest a person when the facts and circumstances within the officer's knowledge are sufficient in themselves to warrant a reasonable person to believe an offense has been or is being committed by the person being arrested. In determining probable cause, arresting officers must consider plainly exculpatory evidence in addition to inculpatory evidence. So when you're factoring probable cause, you have to factor in all the things you know at the time, which may not be very much, but you have to factor them in, for good or ill. So all the things that make him look guilty, you have to factor that in. All the things that make him look not guilty, you also have to factor that in. You may not necessarily have to go looking for it. You may not necessarily have to, do any research or stuff, but you have to at least factor in the stuff you actually know about at the time. That would be helpful. Do that. Under Pennsylvania law, a person acts recklessly when he consciously disregards a substantial and unjustified risk. Viewing the facts in light of the facts most favorable to Harvard, a reasonable juror could find Harvard acted as a good Samaritan by agreeing to give Mazzetti, standing alone and afraid of her boyfriend Sutton, a ride home. Once Sutton emerged from the house, aggressive, violent, and threatening, and then jumped onto the hood of his vehicle T1000 style, a juror could find that Harvard's decision to drive with Sutton on the hood of his vehicle was a justifiable risk to protect himself and Mazzetti from Sutton's abhorrent behavior. Yeah, pretty much. Like all good things, it has to be looked at in context. So was this reckless? No, it's not reckless. Well, normally, probably it is reckless to have someone hanging from the hood of your car if you're driving down the street. Normally, that probably is a reckless thing to do. But like many things in law, we have to factor in other things which the officer knew about at the time. That makes it not reckless. That makes it actually kind of pretty reasonable under the circumstances. So like many things, it's context dependent. And under these contexts, yeah, no, not so much. This is not reckless. There was a substantial threat. He was trying to deal with it in a responsible way. So no. We therefore conclude that, viewing all the facts in the light most favorable to Harvard, a reasonable juror could find that Harvard was not consciously disregarding an unjustifiable risk and could find a lack of probable cause for the crime of recklessly endangering another person. Yeah, if you had looked at the evidence and facts, you would have said, this isn't reckless endangerment because, it's not. Second up, a person is guilty of reckless driving if he drives any vehicle in a willful or wanton fashion for the safety of property or people. If you drive it, recklessly. Willful or wanton within the context of reckless means the driver grossly deviates from ordinary prudence and creates a substantial risk of injury. Like the crime of reckless endangerment, a juror could find that Harvard's decision to drive with Sutton on the hood of his vehicle did not demonstrate a callous disregard for Sutton's life, but rather a justifiable risk to protect himself and Mazzetti. Also, as I think we mentioned earlier in the opinion, although maybe we skipped that part, I can't remember right now, but he did try to stop and slow down to give him a chance to get off. And no, not so much. He had no interest in that. So again, according to his own testimony here, this is not reckless. No. Next up, a person is guilty of simple assault if he attempts by physical menace to put another in fear of serious imminent bodily injury, to remove himself from the hood. So this is where, for example, after Sutton jumped on the hood, Harvard slowed his vehicle multiple times and asked Sutton to remove himself, yet Sutton refused. So he gave him a chance. Further, Sutton, not Harvard, continued his aggressive and threatening behavior towards Harvard and Mazzetti Also, Harvard followed 911 operators' instructions to get off the highway at a particular exit where law enforcement would be waiting. Accordingly, a reasonable juror could find that Harvard did not have the requisite intent for simple assault. Fourth, a person is guilty of aggravated assault if he attempts to cause serious bodily injury to another. Because a reasonable juror could find a lack of probable cause for simple assault, we similarly find that there could be lack of probable cause for the more serious crime of aggravated assault. Yeah, you can't have probable cause of aggravated assault unless you have probable cause of assault, right? Aggravated assault is worse than assault. You can't have probable cause of aggravated assault if you don't have probable cause of assault. So since there was no probable cause of assault, because the reasons are pretty good here, you can't get to aggravated assault because we're not idiots. Fifth, a person is guilty of disorderly conduct if he acts with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, and creates a hazardous or physically offensive condition by act which serves no legitimate purpose to the actor. We did this specifically because we were trying to escape from the bad guy who was trying to claw at our vehicle. Finally, a person is guilty of driving under the influence if they're under the influence of any drug or combination of drugs to a degree which impairs the ability to safely drive, operate, or be in actual physical control of the vehicle. For the DUI charge, Cesnalis determined there was probable cause to arrest Harvard because he smelled alcohol on Harvard's breath and because Harvard was sweaty and speaking rapidly. Although we must consider these observations as part of our inquiry, we must consider them in the light most favorable to Harvard. Although Cesnalis smelled a moderate amount of alcohol on the breath, Harvard informed Cesnalis that he consumed 2 beers 4 hours before the incident, which is consistent with the breathalyzer test. We have the test. It puts him well under the limit, so, Also, yeah, who cares at this point, but whatever. Based on the information Cesnalis knew at the time of the arrest and the horrific events Harvard had just experienced, a juror could find Cesnalis did not have probable cause to arrest Harvard for DUI. Thus, we conclude the district court erred in determining as a matter of law that Cesnalis had probable cause to arrest him for DUI. Yeah, because you knew what was going on. You had all this information. You had the 911 calls, the 911 operators. You knew about Sutton's criminal record. You knew about Harvard's lack of criminal record. Who did you decide to arrest? Not Sutton, the one with the criminal record, but Harvard, the one without the criminal record. Because of his criminal record, which he doesn't have. Because of the DUI, which you have evidence directly against. Because he's on drugs. Because of a blood test that tells you don't have drugs. Where the police lack probable cause to make an arrest, the arrestee has a claim under 1983 for false imprisonment based on the detention. To state a claim for false arrest, they must say that they were detained and the detention was unlawful. Our probable cause analysis for false imprisonment is largely the same as probable cause for false arrest. Because a juror could find Cesnalis lacked probable cause to arrest Harvard, it followed a juror could find Harvard suffered violations of his rights by virtue of detention pursuant to the arrest. Accordingly, we will vacate the district court's grant of summary judgment for Cesnalis as to false imprisonment. We affirm the district court's judgment on Beatty for false imprisonment because of his DRE, and role in detention was based on Cesnalis' incomplete and potentially false information. So Beatty isn't responsible because Beatty was acting on Cesnalis' stuff. And also Beatty didn't really do that much. All she did was do the blood test, so yeah, it's fine. All right, so what else do we got? To prevail on a malicious prosecution claim, a plaintiff must demonstrate that the defendants initiated a criminal proceeding. The criminal proceeding ended in the plaintiff's favor, and the proceeding was initiated without probable cause. The defendants acted maliciously or for the purpose other than bringing someone to justice, and the plaintiff suffered deprivation of liberty consistent with the concept of seizure as a consequence of a legal proceeding. Harvard argues that defendants unlawfully initiated a proceeding against him by knowingly providing false and misleading evidence to prosecuting authorities. We must determine whether a reasonable juror could, viewing the facts in light most favorable to Harvard, find defendants acted with malice or for a purpose other than bringing Harvard to justice. Considering Cesnalis' behavior, the answer is yes. The Court of Appeals is decidedly not happy. They are very unhappy at Cesnalis over here. Yeah, Cesnalis mischaracterized the events and chose to omit crucial evidence that would exculpate him from his affidavit that he submitted to the magistrate judge that caused this whole thing to occur. So he lied in the affidavit. Good times. Cesnalis did not mention any of the credibility issues with Sutton's version of events, namely that he knew Sutton had a criminal history, that Sutton had no visual injuries, or his versions of events was incredible on its face. Moreover, Cesnalis indicated he believed Sutton's statements because of Harvard's reputation for criminal activity, even though there is no evidence on the record of criminal activity. A juror could find that Cesnalis omitted crucial information from the affidavit and misrepresented the facts in order to portray Sutton as the victim and Harvard as the criminal. Sounds, yeah. A juror could further find no reasonable officer would admit this crucial information, which is discussed above creates serious doubts as to whether Harvard had the requisite mental state for the crimes charged. Cesnalis has offered no explanation of why he chose to credit Sutton's statements over Harvard and Mazzotti's statements, and we can think of no reason for why Cesnalis would include such grave misrepresentations and falsehoods in the affidavit. For these reasons, we conclude a juror could find Cesnalis initiate proceedings against Harvard maliciously, or for a reason other than bringing him to justice, which it does sound like that a little bit, yeah. Harvard also argues the district court erred in granting summary judgment for the defendant on his equal protection claim. Harvard brings a selective enforcement claim, contending he was treated differently because of race. Wow. Specifically, Harvard asserts that Sutton, a white male, was not arrested and charged with any crimes despite his violent and aggressive behavior, and yet Harvard, a black male, was unlawfully arrested, imprisoned, and charged despite being the victim of the unlawful behavior. So, yes, Sutton is white, Harvard is black, and maybe the police came to the wrong conclusion because of race. You know, this is just a horror show. It's just a horror show, and it's difficult. It's somewhat difficult to believe that there are people that they're this horrible out there. There are horrible people everywhere. I guess I shouldn't be that surprised, but that's so blatant, so obvious. It's like, man, geez, Lord, it's just, yeah. Let's press on. A juror could also find there was no rational basis for disparate treatment towards Harvard except on the basis of race. Cesnalis chose to ignore overwhelming evidence that Sutton was the aggressor who acted unlawfully in the situation and decided to credit Sutton's incredible statements. Incredible in the literal sense of not credible. According to Harvard, Cesnalis repeatedly referred to Harvard as boy while demanding that Harvard complete the test. Quote, "You understand me, boy. I want you to blow into the breathalyzer." Super duper. Harvard was 46 years old at the time of the incident. Because of the long use of boy as a slur against black people, this could be deemed that maybe there was racism here. Cesnalis also insinuated Harvard has been smoking crack cocaine. Cesnalis insinuated Harvard had been smoking crack cocaine, even though there's no evidence whatsoever in the record to support this, including the blood test, which showed that there were no drugs in his system of any variety. A juror could find this was further evidence of racial animus based on historical associations of crack cocaine with a black community. Maybe racism. Wow. Cesnalis' deliberate omission from the affidavit and potentially falsified information, suggesting Harvard had a prior history, which he didn't, all lend support to Harvard's allegation that Cesnalis' actions were motivated by a prohibited reason, in this case, racism. So that is the end of our current coverage of the case of Dwayne Harvard versus Christopher Cesnalis. Yeah, this is just like comedy. It's I don't know. It's something about it is so wrong. It's hard not for it to be funny, but man, oh man, what a horror show this is. Maybe this is a black comedy, to use exactly the right words under this circumstance, because it could only happen because Dwayne is black. Dwayne, who went to a sports bar to watch some sports, decided to give Marzetti, a girl, ride home, and then her boyfriend decided to cling onto the car T1000 style. And then Cesnalis over here decides to not prosecute the boyfriend and go after Harvard for 8 different crimes that don't make any sense in lieu of the facts. I hope that Harvard gets a whole bunch of money. I hope Cesnalis goes away from the force forever, because Cesnalis sounds like a horrible, horrible racist. This is just a horror show. So wherever you're out there, Dwayne Harvard, I hope you get a whole big pile of money, because this sounds really, really bad. And I suppose that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.